Hi everyone, welcome to our class on predicting dangerousness. Today we're going to talk about prediction, that is quite of the psychologist's core to work on it. We're going to talk about bail, a global topic, and we're going to talk about Tarasov. Tarasov is really famous, a term that it was made well known for a terrible case that happened in the US, but every single country has something that is very similar to Tarasov right now. So let's start with our class of today.
All right, guys, thanks so much. So we're going to be thinking about across all these three things, as Sydney said, is future bad acts. Like, how do we decide and how do we predict whether or not someone's going to do something bad in the future? And as we mentioned, the legal system, almost maybe everywhere in the world, is filled with this, right? These risk assessments. An assessment is somebody's going to be dangerous. And when I say dangerous legally in the United States, what we're sort of thinking about is a likelihood to be physically violent to others in the future. Now, this also can, of course, include a violence to oneself, like suicide. And so risk assessments are often thinking about what sort of physical harm I should go about in the world and commit. And these predictions are often made in the legal system, but one of the things we struggle with is, well, how accurate are they? And we can actually use a framework that we use in lots of different parts of the legal system. If you take other legal psychology classes with myself or any of your other professors, you'll hear this framework. And it's to think about false positives and false negatives and true positives. So let me lay that out for you, what that means here to us today when it comes to accuracy of predictions. So a true positive when it comes to whether or not someone's going to be violent in the future. So that means I went about and I said, you are going to be violent in the future. That is if I say you're going to be violent and you are violent. It's truly positive because I'm making a prediction that something is true, something is this way, it's a positive thing, and it's actually right. So you can sort of think about this, use the example, but like pregnancy tests. If you take a pregnancy test, back in the day, I'd say COVID test, but now we'll go back to pregnancy tests. Take a pregnancy test and it says that you are pregnant. It's a positive, right? You're getting the little positive. And that's actually right. You are pregnant. And the converse of a true positive is a true negative. So I'll give you a second. Think about what a true negative might be. So a true negative is when you're predicted not to be violent or not pregnant, and you actually are not violent or not pregnant, right? So the idea is we're making a negative prediction, and that prediction is right. So true positive, we're predicting you to be violent, and you are. True negative, we're predicting you not to be violent, and you are not. So those are good, right? Those are accurate predictions. But we also have when you make an incorrect prediction, and that's a false positive or false negative. And a false positive within predictions of violence is I predict you to be violent and you are not violent. You wouldn't actually go out and commit a crime. So I say, hey, this person's likely to go out and hurt themselves or hurt someone else. And that's actually not true. I'm wrong about my prediction. And the other side is the false negative, where I think you are not going to be violent and you actually do prove to be violent. And so as we talk today and as you think about your policy projects and you work in your groups, I want you guys all to think about these false positives and false negatives and how they play out in the world and how are we likely to get evidence of it in the world. Now, false negative with violence, you're predicted not to be violent, so we're going to release you, right? We're going to set you free and you're going to go hurt someone else or hurt yourself. So we have really good evidence of it. But with a false positive, if I predict you to be violent, if I restrict your freedom, and your chance to actually be part of society, to see your family, to interact with the world, but you actually wouldn't be violent. What evidence do I have there? And is this actually sort of escaping some of our calculations? And so think about that as you're going through with your policy projects. What are sort of the ways and the impacts of the choices we make? And I know, Sydney, you guys have that as a question too as well, and how to think about this, right, from a scientific framework.
Yeah, and many times you're going to see that in our test books as type 1 and type 2 errors in legal psychology. So you're going to see people saying, oh, did you predict that this child was at risk? Did you predict this correctly or incorrectly? It was true positive, true negative, false positive, or false negative. This is quite common language when you read textbooks in Portuguese that are going to talk about this type 1 and type 2. Keep in mind that this is what we're talking about here. It's the same thing. We're talking about how do you make predictions that and how you're going to check them on the real world and if they hold true or not. And another thing that is really important for us to know is that risk assessment, especially in Latin America, is quite a varied field if we're going to be nice about it. People do a lot of different stuff in risk assessment, and they are not really evidence-based risk assessment. And one of the things that I always like to cite is James Garbarino work. He has a great book that is Listening to Killers, the title of the book, when he's talking about people who already committed a homicide, and he's going to listen to their stories, see the risk factors, but he cannot say, well, I was sure that that person was going to kill someone. I can only say after it happened. So there's a lot of people who say, oh, I can predict behavior, but it's going to be filled with false positives and false negatives. It's really hard to make good risk assessments when you do not have good information or good measurements to evaluate these kind of things. When you think about the false negatives in the US, you have a huge scope of work that you do not have in Brazil and Mozambique and any other developing country. So sometimes when people try to copy and paste those kind of research in our context, they get a lot of false positives that we incarcerate a lot of people that are not violent. How do we know that? After 15 years, they get out of jail and they are not violent. You know, we have a lot of those different stories in Latin America. So we always have to be careful with risk assessment. Is that person really a danger to society, to others, to itself? We have to be really careful and to actually create a body of research in developing countries about this.
Yeah, and that's something, one of the issues with risk assessment that we've been struggling with in the United States is within the context of bail. For those of you who are not familiar with it, I'll cover more in bail in a second, but it's the idea when someone's waiting for trial, right? We haven't found them guilty yet. We're still waiting to decide their innocence or their guilt. How do we decide if they should be released, right, to go out into society, or should they stay in jail? And part of this decision is, how do we know if someone's dangerous, this risk assessment about dangerousness. So what is bail? I'm first going to cover what is bail in the United States, and then Sydney will help clarify for other countries as well. But within the United States, bail is the release of an individual with a guarantee that they will return within an appointed time frame for hearings and prosecution of a case. Clear as mud, right? So the idea is that it's just that you, rather than being held in jail or prison while you're waiting your trial to decide if you are guilty, we're going to let you out, and it's for some sort of guarantee or promise that you will return. And we often colloquially refer to the money or the property that guarantees or secures your attendance, right? Like you give $10,000 to promise you will come back. We often call that bail as well. So when we're thinking about this in a crime, people often get this confused. Bail is what has happened after you've been charged and after you've been arraigned, which usually happens in 48 hours in the United States when the charges are read against you, but well before the trial. The bail decision is while the sort of trial is getting built and prepped and going to happen. And in the United States, there's actually in our Constitution, because it's so fundamental to the sense of who we are, this idea of bail and whether or not you can restrict freedom. In fact, arguably, Sydney and I are discussing this, but most of the Constitution is about restricting freedom, right? When do states and the federal government have the right to restrict individuals? And so the US Constitution protects not against the idea of bail, or doesn't provide you with the right, but it protects against is excessive bail. And you do not have an absolute right to get out on bail or be given an amount. The courts can deny it. But what the courts have to do when they're setting bail is they have to find a compelling reason to deny you bail. And within that decision about, is this compelling? Is this a good reason to hold you? We consider predictions of dangerousness. And you can look to this US v. Salerno case. And what they say there is you can hold an individual in preventative detention, jail, without bail if they present what we say is a demonstrable danger. And this is where the psychologists get involved, right? The mental health workers. Because we're deciding here, are you dangerous? Are you going to go out and do something if we release you? Or are you the sort of person that we can release you and all will be well? So there's no constitutional right to release also if you cannot pay the bail. The court can set what they think is a reasonable bail. They cannot set an excessive bail. But this raises a really cool empirical question, right? Thinking as empiricists, as scientists, as the studiers of, whether or not things work, does bail work, right? Do we need this system? Does it work? Is this what guarantees people to come back? Are we good at deciding who should and who should not get bail? And is payment necessary? And I know there's similar issues in Brazil and Mozambique that are being considered.
And one of the things, almost every single developing country has a bail system at place. And almost every single developing country has its own characteristics of bail, for 48 hours, 96 hours, 1 week, 1 month, that changes across our countries in the global south. But our discussions are mainly in the philosophical area of what is the philosophical principle of bail. And this is something that Abby and I were talking about, that sometimes in the US, there's a lot of empirical work and empirical questions about, and this kind of philosophical discussion is more in the legal area. Lawyers or soon to be lawyers are going to be discussing that. While in Brazil and Argentina and Chile and in Angola, Mozambique, many times that's the main discussion, the philosophical area, and we do not have a lot of empirical data if bail works or not. But I think that question that we set for you guys here, how to set a fair value for bail in countries with high inequality, is something that is quite common in every single philosophical discussion. But that's not a philosophical question. That's an empirical question. We could test that. So I think one of our ideas with this class is to show you guys that even things that are considered to be philosophical can be tested, and we can find some answers for that and to try to change our society. How we could do that? Someone that was stealing something but is from a very low income area, very low socioeconomic status. How do we set bail for a person compared to someone that had a corruption charge against him or her? So I think those are main points for us, because a lot of our philosophical questions can actually be transformed into empirical questions, and we can be part of that conversation.
Yeah, and that was so within the United States, right? Psychology has played a role since for a long time, but especially in the early 1960s, getting involved, the Vera Institute of Justice, in studying, well, does bail even work? And I'm enjoying that PowerPoint only thinks that I need translations. But we will get translations for all of you for everything. But starting in the early 1960s, Vera studied within the New York's court system, hey, can we actually help judges make decisions about who should be released, right? Thinking about the dangerousness of it all. And so what they did is they had an experimental group and a control group, right? Nice, beautiful experimental design. Individuals were sort of randomly assigned, or judges were randomly assigned. And in the experimental group, the course used a point system that rated the applicability of release. So they were making what we call a statistical prediction. They used empirical predictors. Someone came in, they gave them a score based on these predictors and decided you're going to go off free or you'll stay here in jail until your time of your trial. And in the control group, no point system. We made what we called a clinical prediction, right? The judges are basing this based on their expertise and their knowledge and their world experience and their gut. And so as a reminder, as you guys have thought through this class, you'll see time and time again that sometimes we have statistical predictions. We're using points systems. And sometimes we have clinical predictions. We're giving like a holistic overview and sort of a gut check on this based on your expertise. So what they found was that in the experimental group, judges were releasing about 60% of those who were recommended on their own recognizance, which means without bail, just off they went, right? Without actually having to have any bail in that case set, because they felt that they were a safe release. In the control group, you actually only had 14%. So it's a very large difference, a stark difference, right? And as always, when we give you numbers, translate that into, or percentages, translate it into the millions of people that we see every day in the judicial system. And if you look sort of forward in the most recent study that we can find in the state of bail in Manhattan as a comparative, about half of those charged are actually released prior to trial, about 45% felony and 43% jail to trial. But few are released without bail, only 18 to 13% of the cases. So sort of going back to the rates of clinical predictions that we saw in the early 1960s while Vera was involved. And what we are finding time and time again is bail is often set at a rate that most defendants cannot afford. And we are not talking of millions of dollars. We often hear that in these big cases that hit the media. We're talking $500, because when you set bail at $500, about 40% of your defendants are going to remain incarcerated because of the incredibly low socioeconomic status of a lot of these individuals, and also because of the tough choices this asks people to make. You're going to hear more about this in a video here in a second. But when we set bail at $500, you're asking someone to decide if there's going to be food on the table for their kids. You're asking someone to decide if their kids are getting new shoes. You're asking them to make a lot of really tough choices, because this is, can you produce $500 today? The other thing we find from the research is that actually people do show up for court. Maybe, I don't know, students have told me in the past they're surprised by this. But in Manhattan, the failure to return rate is quite low. It's 4% for felonies and 7% for non-felonies. So that's 96% of people who show up to court for their felonies. And the reason is actually not because of the bail. It's because Manhattan involves what it has called a comprehensive supervised release program. So every defendant gets a rating, those lovely point systems. Remember, statistical predictions, point systems. And on that statistical prediction, that tells you the amount of contact someone has to have. If they are low on the system, you give them a phone call, right? If they are high, you have face-to-face meetings. You help them develop plans. They get text reminders. And so it increases the amount and the nature of the contact, the higher the rating. Now, this is great for the individuals who are released on bail. But the question is, why are so many people still within jail on bail? And that's what we're going to think about in this next TED Talk.
I will never forget the first time I visited a client in jail.
Okay, so one of the reasons we show this video, in addition to her sharing all those incredible statistics and giving you guys background on the bail system and thinking about a change, is that you guys will be doing your own policy projects. And as part of that policy project, you will think about a change you want to see in the legal system, and you'll support it with research. And so here, Robin Steinberg, you see giving her sort of opinions and takes on what needs to be changed in the legal system. And then you see her using research to support it, and then her coming up with an outcome. So you don't have 14 minutes, you have 3 to 4 minutes, but it gives you a nice sense of what you could think about for your own policy project, and sort of how science and statistics can be used along with, as Sydney said, ideas of philosophy and freedom and arguments to sort of set out whatever it is, arguments you guys want to make on your own policy project at the end of the course. So we're going to shift from bail, which is, the prediction after you've been arrested, to this idea of Tarasoff and the Tarasoff duty. And Tarasoff arises out of a case out of California. And the defendant in this case, he was a UC Berkeley student, and he implied while he was in a therapy session with his therapist that he was planning or intending to kill Tatiana Tarasoff, which was a young woman that he had dated. And his therapist actually notified the police and told them. Campus police and a psychiatrist, they showed up at Tarasoff's house, they interviewed him, and they decided that no further action, not Tarasoff, they showed up at the defendant's house, and they told him that no other further action was taken. But what they didn't do is they never identified and warned Tarasoff herself. Tarasoff, the one who was the recipient, or would be the recipient of the threats, right? She was the one who's potentially in harm. And so a question arose whether or not they should. Because at the time, the therapist didn't have any duty to disclose. But 2 months later, the defendant went and shot Tarasoff, stabbed her, and violently murdered her. And what happened was her parents sued. And they sued the University of California, they sued the campus police, they sued the therapist, and they sued the mental health workers. And they sued them for something that's called wrongful death in the United States. And what that means is that my loved one died and they should not have died, and you are responsible for that death. It was a wrongful death. And they sought civil action, right? This is not a crime. You're not going to spend time in jail, but you might get money. And what was surprising about this lawsuit at the time was that the mental health workers, the defendant's therapists, they didn't have a duty to Tatiana and her family at the time. They had no requirement to tell anyone. They had no requirement to do anything. And so the suit was a little surprising to see, well, did they have anything to argue? And the California Supreme Court, what they did is they actually established this whole new idea. At the time, it was very earth-shattering. I know it's not probably to all of you now, but at the time it was earth-shattering. And what they said was that when a patient presents serious danger of violence to another, the therapist must take reasonable care to protect the intended victim. And so what they have to do is they can either call the intended victim, they could call Tatiana herself directly here, they could have notified the authorities, or they could have taken whatever other steps are reasonable. Now, in the end, the therapists did what was required under them under Tarasoff ahead of time, because they called the police and the police took action. But what was so surprising about this is that the Supreme Court, the California Supreme Court, had said, we appreciate that confidentiality is, central to the therapeutic relationship, but there's an edge, there's a border. And that edge and that border is when someone presents the danger of harm to another or harm to themselves. And that at that point, you have a duty to do something to protect the intended victims. So this was very surprising, but it's become the law in the United States almost everywhere. And in fact, it is part of almost every ethical test that you will take to become a therapist here in the United States. And so I have an example of an ethical question that you would see on one of these tests. So let me give you it. And maybe I'll ask Sydney to actually answer this. You can answer it based on what you think the US law is and what you think the Brazilian law is. You're on the spot. We didn't practice this. Sorry, guys. Okay, so scenario one. You have a client who was fired from his job. During one of your therapy sessions, he mentions that he's really angry with his ex-boss and he's planning to go kill the boss tomorrow. I'm sorry, he's planning to go break some of the windows at his former place of employment. Do you have a duty to warn if he's going to go break the windows in his former place of employment?
As someone that thinks the Americans love to sue, I would say yes. If I'm the therapist, I'm always warning everyone. I'm not the one getting sued. If I'm Brazilian and he's just breaking some windows, you see, that's where it gets interesting, this kind of class, because here in Brazil and most of Latin American countries, this is something that the board of psychologists would decide upon if you should or should not. And that's where Brazilian psychologists get really mad at the board, because it's not very clear if they should or should not, because he's going to put someone in physical danger, breaking some windows, or yes or no. That's the kind of problem that we have with our ethical codes. But here in Brazil, yes, you have to warn them. In the US, I would warn them because I would cover me, avoid the lawsuit at all costs,
Well, surprisingly, probably for you, on the US ethics exam, this was, for one of the examples I found, this was a no. As long as you don't think that there's going to be harm to someone's physically, you don't have to warn. Now, if you thought he was going to throw the windows and break some windows and someone was in order to hurt somebody, then yes. But breaking physical things, you don't have to do. The question is this one for scenario two. If he said they're going to go kill his ex-boss tomorrow, yes, you would, because then there's physical harm to another. So this is not about property damage in the US, at least. Someone can commit property damage. They can go, scream from the top of their lungs if they want to, but it's about physical harm to oneself or physical harm to the other. But I respect your concern.
and here in Brazil, when you have psychological damage, you have the obligation as a psychologist to warn the other person, especially if that person is a minority or is someone that is considered to be vulnerable, a child, an elderly person. So it's not just physical damage that you as a psychologist must warn, must report. So this is an interesting difference because since the Brazilian new constitution, we talk about this on the first class that we didn't record yet, but we will talk about on the first class about the difference between the constitutions. And the Brazilian constitution, the newest, and hopefully the last one, says that psychological damage is one of the things about children, elderly. It has a lot of different psychological aspects to it. So this is one major difference in when you should report or not if you are in the US or in Brazil or in Mozambique.
Well, let me just clarify one thing. In the US, you actually do have to report if it's a child or someone who's vulnerable. If it's your boss and, he's just a 40-year-old, woman or man, then, less concern unless they are, in some sort of protected class, like, they're elderly or have some other reason. But yes, just to clarify, in the United States, if you do have concerns that a child is being harmed, including psychologically, you have a mandatory duty to report in the United States. In fact, in most states, it's actually a criminal question. So please do make sure you report if you have concerns about a child being harmed or an elderly person being harmed. But yes, I think that's like what we're watching, right? Is both of all the countries grow with this idea about like, when do we step in and how do we step in? And the United States, Tarasoff has like gone to grow most, but not all, but almost all states have established a Tarasoff duty. The duties vary depending on the states. I wouldn't even be brave enough to say what each single state does. Florida has a duty to warn for many mental health professionals. It's dependent on your job title. It's permissive for some clinicians. For some clinicians, it's not required, but confidentiality is waived. For some, you have different standards. And as Sydney said, it depends on who the focus is. If it's a child or someone in a protected class, right? A child or an elderly individual, you have to report because that's a mandated reporting scheme. In the United States, there's been a renewed focus on Tarasoff because of our mass shootings, both the recent and past ones. And the question now is, what signs are enough for mental health professionals to warn? Because with a mass shooting, you're not talking about an intended victim like Tatiana. You're talking about someone saying, I just want to hurt people in general. And so there's been discussion in the literature and by the courts about, is this an area for growth for Tarasoff, about how and when do you warn? And I know we talked about this a little bit, but do you want to talk a little bit more about the Brazilian statute for children and adolescents?
Maybe the biggest impact that Tarasoff has in Brazilian law is the Brazilian Statute of Child and Adolescents. So this is the first time that the duty to protect is presented in Brazilian law. So it's a mandatory reporting was necessary for children and adolescents, and this is a ripple effect of the Tarasoff law. And it's really interesting that because it creates what we call failure to report. If you know as a professional of some sort of situation where a child or adolescent is having its rights, his rights are not being respected, you have to report. It's mandatory. And you can have a criminal or a board investigation. And what's really interesting is that this law has been changing in the past 25 years. But in 2002, it has a major change that in cases of suspected child sexual abuse, every single professional that saw the child is responsible for his protection. That was a major change in our law. So when you have special classes, because some professionals should report, some should not, some can report, some are allowed not to report, that is over in Brazil. Doesn't really matter if you're a social worker, if you're a psychologist, if you're a teacher, if you know something is happening, you have to report. And this now has a different ripple effect because right now in Brazil, we have what we call the Human Rights Hotline. So every single professional then knows about every single human rights violation is mandated to report, and you can do that anonymously because it can be dangerous for you to do that depending where you are. So Tarasoff had a major impact in psychology, in social work, in education, in healthcare. So a lot of the things that we see in Brazil today as the national system to report violence is a ripple effect of this terrible death of Tatiana Tarasoff. So we see that it doesn't call Tarasoff because she's not Brazilian. It doesn't have to, it's not directly related to her, but it created a ripple effect in a lot of different countries. And you can see that in Brazil as well.
Yeah. And I think that's also for the United States, right? In the US, if it's a child or an elderly, there are no exceptions. In fact, in many states in the United States, ordinary citizens are also required. It's not just limited to professionals. So I have to report, of course, as an educator in the United States and someone who studies with kids, but even anyone is really under sort of a duty to report. And we do that, right? Because kids may not have the same ability to help protect themselves. They may not know who to call and they may not know how to reach out to. And if you are a FIU student or an international student, you're really interested in mandated reporting involving children, Maureen Kenny here in our department is a worldwide expert on the issues of mandated reporting, and she teaches classes on this. So I encourage you to take more on it, and you can, learn from her. So if you guys have any questions, as we are saying at the end of every one of these videos, we are here for you guys. It is an online class, but we are real people with real ideas and real hope that we can talk with you guys about them. We're excited to hear from you. So reach out to us on Teams or via email. Just a reminder to add us on Teams so that when we get a notification that you want to hear from us versus somebody else in the class. And we hope that you guys are, coming up with great questions, learning from each other, really growing together, and learning to ask good questions together for your policy pitches. And we are thrilled to hear those soon. So have a great day, guys, and we will talk with you all in the next video.